Hi there, and welcome to this presentation. New year, new deal. Getting ready for submitting LOIs in 2026 and what you can do in right now, so you're ready to go in 2026. And so, um, really glad for everybody who's joined today. I know this is a busy time of year for everybody, so this is a good sign that you're serious and looking to get a deal done this year. Um, we have the purpose of this session, is to help buyers strengthen LOIs, clarify, what must be completed before the year end, or how you can prepare before year end so you're ready to go in 2026, and then go through a checklist of a readiness checklist here at the end that we can talk through and see, and you guys to help you guys plan for what's going to happen in 2026, which is hopefully a lot of deals get done. Um, we're kind of shifting from just thinking about buying to being ready to submit a winning LOI in 2026. That's the goal of today. And so we're going to be talking through that, and let's go ahead and get started. We only have 30 minutes today, so we're going to jump through. Sorry, next slide. There we go. All right, so today we're going to be here's kind of the agenda. We're going to go through an overview of a letter of intent, talking about negotiating non-binding terms, binding terms, working capital, potential pitfalls, and then get into the kind of the non-negotiables, 2026 preparation, and checklists. So that's the goal for today. We have a lot of material to get through. I'm going to speed through the beginning part here because it's really just kind of giving you some background on it, and so that shouldn't take much time. I want to get through that quickly so we can really focus on really that last bullet points on the non-negotiables, and then preparing for 2026 and what you need to do. So that's the idea. If you have any questions, please put them in the chat. I should be able to. I'll be checking that from time to time here, looking up to the right to see the chat. If anybody's had a question, happy to answer questions along the way. But that's the idea for today. So we'll get going. I guess initially, before we jump in, here's the first slide to get into the meat. But really, I wanted to give you a little more context on my background. We're at Doida Crow Legal. We're lower middle market M&A firm, and we do a lot of deals both buy side and sell side. This presentation is obviously focused on buy side and trying to get buyers prepared. Stop just looking at deals and actually submitting LOIs, and be prepared to do that in 2026 so you can get a deal closed. Most of our deals are kind of in the on the buy side, at least $3 to $20 million range. So a lot more on that 3 to 7 million, I would say. A lot of SBA deals, and so that's kind of the context that I'm thinking about here. But happy to answer questions if you have a question about something that's outside of that area. Let me know. But let's jump in. So quickly, purpose of an LOI is really to agree on the major terms in the deal, and to kind of get those deal breakers out of the way before you spend a lot of time and money on due diligence, Q of E, lawyers, drafting documents, all that. And so it's really the backbone of the M&A process in my mind, because it really sets the stage for what's going to happen, how you're going to negotiate the transaction, what are the big terms, making sure buyer and seller are on the same page on those major terms, and how you've arrived at those major terms, which I think is a big piece of this, which we'll get into. Obviously, this slide talks about buyer versus seller. First bullet point's the same on both. Agree on those major terms so that you know what you're getting into and everybody's on the same page. Seller has more thoughts about keeping confidentiality and things like that, which can be an LOI, but it can also be a separate NDA or confidentiality agreement you sign. And then on the buy side, it's really to lock up that seller with exclusivity, to make sure that you're not just wasting your time on due diligence here while they're shopping the deal around, and may pull the deal from you for just a small price increase or something like that. So that's really the main purpose of the LOI. But I can't stress the importance of it enough. I do think it is the backbone of the M&A process, and it is really helpful to have a good LOI in place when you're going into a deal. All right. So negotiating an LOI, I always like to say that it's an art, not a science. You got to kind of take your time to ensure the LOI is as specific as possible. But that's not always the case. Sometimes you're going to leave something more vague if you want to kick the can down the road, or you want to get the deal started, or you think that's something you can overcome later. So there's always some art to it, as opposed to just hey, here's a formula, or here's a template LOI that you can use every time. You do want to make sure you include any deal breaker terms. I would say that's the major piece of it. Make sure you have those in there. Deadlines, and I like to say it's nice if you can take your time on them. But I know the process, especially on the buy side, does not lend itself well to taking your time. Sometimes you're under pressure to get these in by a certain deadline, or to get it in quickly to see if you can get it accepted before 20 other offers come in, especially on those deals that are right in the wheelhouse of a lot of people searching these days. That it can be a very competitive process. So it's kind of oftentimes it's a lot harder to take your time than possible, but if you can, it's great. And then, as I said, include deadlines. I think that's a big piece of it. You want to make sure that you're including deadlines along the way. That's going to give the seller some comfort that you're continuing to move the process forward, and then also set some expectations on your side on how you're going to manage the deal process. It also shows that you're prepared, right? So if you can show that the seller that you're prepared to follow a process and you've thought through it, that's great, and it's helpful for sellers, I think, to accept them. And why I say take your time negotiating the LOI, if possible, you have to move very quickly afterwards. So the idea is be ready to move fast as soon as an LOI is signed. And so we'll talk about some of those things here later on how you can prepare for that. All right. So quickly, not usually a LOI is mostly non-binding, right? That's the way you want to structure it. And you want to make sure that you have structured it that way. There's court cases every year where LOIs are fought in court to say that they're binding, right? Because there was terms or emails or something like that led one of the parties to believe that we were in a binding agreement, and it doesn't move forward. Now, I think that's a rare situation. It usually happens in much larger transactions where somebody has made some mistakes along the way, but usually there has to be enough money on the line to make it worth the litigation. And so that doesn't happen much in the lower middle market, I would say. And most LOIs are structured in a way that it's clear that it's non-binding and there's no requirement to actually close, but definitely make sure that the structure is set up that way. But these are all the provisions in an LOI that are typically considered non-binding. Purchase price and terms. Those are in there, but they're non-binding. You don't have to close under that. You're not guaranteeing that. There's some potential for change there. Indemnification framework. That's non-binding. The key closing conditions are non-binding. Really, it's probably easier to say that it's all non-binding except a few binding provisions, which we'll get into in the next slide. But management arrangements, due diligence, all that is typically non-binding piece of the LOI. Then we get into the binding terms. So binding terms, and these are important for both buyer and seller. For one, exclusivity, that's a very buyer favorable term. So you want to make sure you have exclusivity in the M&A deal so that the buyer or the seller, is not out there negotiating or soliciting other offers from potential buyers. And what is the period of exclusivity? That's a critical term because this is a binding provision in the LOI, and that will drive timelines for your diligence and also for negotiating agreements. And so that's a very important provision, and it's not uncommon for those periods to get extended, but it's better if you can negotiate those up front on how those extensions work and what might trigger those extensions. So we'll talk more about that later in other slides, but that's definitely a big piece of it. Confidentiality obviously is a big binding provision in an LOI. Maybe the LOI just references a NDA or confidentiality agreement that has previously been entered into, or the LOI itself may have some confidentiality provisions in it. Either way, that's going to be a binding provision. And so that's something to be aware of and to be ready to agree to as a buyer. Honestly, it's really shouldn't be a big issue for you to agree to a reasonable confidentiality provision, and most sellers are going to require it. And so it's just, that should be a non-issue for you, but something that's going to have to be in there, and it's going to be binding. Expenses, that's usually a binding provision. It just says that both parties are paid their own expenses for, due diligence and preparation and entering into the LOI and all the portions leading up to closing. Those are all kind of handled by, you pay your own, everybody pays their own expenses along the way. So that's a binding provision. And then governing law is another binding provision in there, usually sets the stage for what jurisdiction is going to be the governing law for the transaction. And so it governs the LOI, and it also will govern the transaction documents if you get that far, past the LOI stage and into actually drafting the purchase agreement and ancillary documents. The governing law is going to be a binding provision, and usually that's a non-controversial thing. It's usually the law of the state where the transaction is being conducted. So again, that's another binding provision, but not usually an issue that gets negotiated. Working capital. All right, I made a separate slide for this because I think working capital is an important one to have. This goes back to the art and science of the deal on how you define it, and is it subject to due diligence or not. Sometimes as a buyer, you may get enough information from the SIM or from other high level financials that you get upon submitting an initial NDA or confidentiality agreement, and that might allow you to come up with a definition of working capital. And so that's an important term, though, and this is one that's often misunderstood by sellers. And so I think taking the time to really define this in a LOI is important, so that it doesn't lead to issues later. Because again, that's one of those issues that sellers oftentimes don't understand, especially if they don't have an intermediary that's representing them that's savvy, that can help them understand what this means. And I've seen it cave deals later because it becomes a surprise later, or it's not well defined in the LOI because it says it's just based on historical working capital or something like that. Buyer comes up with their working capital calculation, and the seller is not happy with it, and the deal dies. So I think this is an important one. If you can define the term because you have enough information, that's great. If you don't, then you got to have some definitions on how you plan to calculate it, right? And so maybe it's subject to getting a QOV and having your QOV provider come up with a working capital calculation, but definitely having some definition of how you're going to calculate that, whether it's based on historical working capital, something like that, and specifically defining what current assets and current liabilities might be. Those things help you down the road to show the seller, hey, we agreed on this up front. We agreed on this in the LOI. We agreed on the process for determining working capital, and here's how we've determined it. If you have any objections, let us know how it differs from what the LOI says. So getting that set forth in the LOI, I think is a great if you can, but that's one of those ones that you got to always be thinking about and communicating with the seller along the way, because I think, again, that's one of those issues that can pop up late in the game and cause deals to die. Okay, potential pitfalls. So, from a buy side, I wanted to take some time here to talk about some of these potential pitfalls. As the buyer, oftentimes you're preparing the initial LOI. 90% of the time that's the case. Every now and then it's done the other way, where the seller has an LOI that they're presenting, but most of the time it's the buyer presenting the LOI. So these would be situations that may come up on a red line back to you, right? So they may change the exclusivity period. And so I put fake exclusivity as a potential pitfall. And so, you can see this from time to time, especially on broker-led deals, where they're trying to, they don't want to take the business off the market necessarily because they've seen deals die. And they want to be able to, not lose that momentum of collecting potential interested parties. And so you may see something like, we will still market the business for sale, or we won't remove the listing. We'll but we won't accept any other offers, as an example. Or sometimes they've gone as far as I've seen. We'll leave the listing up and we'll continue to send sims, but we won't accept any offers. And so that, I think, is a problem from a buy side, and it really turns it into a fake exclusivity in my mind. And the reason is because until you have a purchase agreement signed, there's a million ways out. This is a non-binding LOI. And so if they're still accepting, entering into NDAs, still sending sims, still have the business listed, there's a good chance that they're going to receive offers, and people may provide unsolicited offers or just offers right out the gate. And if that offer is better than the offer that you guys have struck, even though they haven't done due diligence and may be subject to a retrade and all that, the seller may be, in a position where they're trying to cave this deal. They're trying to get out of the deal with you, and they're negotiating in an unreasonable manner, or they just have much more leverage than I think they should after they've agreed to the terms that you provided in your LOI already. So being ready for that, I think, is important, and that's a potential pitfall that I wanted to highlight. Second is unrealistic due diligence timelines. This is another one where the seller is going to say, you got to do this quickly. They don't like the exclusivity period, and they want you to make sure that you're doing your due diligence quickly. And so I think that makes sense. They want you to move quickly after you've signed an LOI, after the parties have signed an LOI, but it's got to be realistic, right? You have to have time to actually review the documents, and this will depend on the different, what type of business it is. How good are the financials? Do you need to recast them? How many contracts have they entered into? How many employees do they have? There's a lot of different things that may make that time different. And so you got to really think about what is a reasonable timeline for you to complete due diligence. And, it also goes, do you have, advisors ready to go quickly as soon as that due diligence is ready? And so one of the things I would suggest for due diligence is, if you're getting a lot of pushback on the timing that you've suggested, a 90-day due diligence period or 60-day or whatever you have in there, if you're getting a lot of pushback, one of the things that I often do for buyers is that we make sure the clock doesn't start on that due diligence period until all the documents are delivered, right? Because it does no good for you to sign an LOI and then wait with a 45-day due diligence period if you don't get the due diligence documents for 20 days. So are they ready do they have a data room set up? Are they ready to provide those? And so you can really get around some of that by saying that the clock starts once you've responded to our whole due diligence request list, and that we've had access to a complete data room full of the due diligence documents. So that's one suggestion that might come up on how to combat that if you have a lot of pushback on the due diligence timelines. That also applies to the exclusivity. I guess I'll go back there quickly. Exclusivity could be tied to different. If you're getting pushback on the timing for exclusivity, you might have a tiered exclusivity where, hey, it's exclusive for, let's say, 45 days, and provided that if we present a purchase agreement within that 45 days, then it gets extended another 30 days or something like that, so that if they know that you're moving forward and you are actually working on the deal and providing a potential purchase agreement that starts to get negotiated, then that exclusivity should extend, right? That you guys are moving forward, you're doing your part. And so there might be some areas there where you can push back to get a larger or a longer exclusivity period if you're getting a lot of pushback on that. So that's a big one. All right. Next big pitfall I have is a failure to anticipate terms and limitations of the lender. So remember, if you're getting an SBA loan, a lot of times you're going to have, every time if there's a seller note involved, you're going to have a subordination agreement that might be on standby, depending on if it's part of your equity injection. So you have to know what your financing terms are in advance of submitting this LOI, meaning that you have to have have had those conversations with lenders and other advisors, or to the extent you don't have that experience, to know what the lender is going to require, because you definitely want to get those in the LOI in my mind, so that you doesn't turn out to be a big issue later. So, that's in addition to working capital. I would say financing terms are a big one that I've seen kill deals late in the process because there's a failure to really think about it, or put it in the LOI. So if the seller is learning about a standby or subordination, right before close, that's going to be a big potential issue. Other issues that I've seen is earnouts and transition services that aren't really aren't well defined in the LOI. For example, transition services that go over a year, you got an SBA loan and there's no rollover. Earnouts, those aren't allowed with an SBA loan. So things like that might be in an LOI that are going to have to get taken out once you talk to the lender. And so failure to anticipate those are a big issue, and I think something that really needs to be thought through prior to submitting an LOI. The other one is leaving room for retrades and or not including assumptions. I think leaving room for retrades is more of a sell side issue, but on the buy side, I would say it's really this not including assumptions. So when you're putting the purchase price and terms in there, you want to add assumptions for how you've gotten to that purchase price and terms. So this is based on some, here's the purchase price that we're offering in this LOI. Here's the terms of that. There's going to be a seller note, for example. What are all those terms? And here's our assumptions in coming up with that purchase price. This is a 3 times EBITDA calculation based on what you've provided to us in the sim, that you have this as EBITDA, right? Or seller discretionary earnings or income. And it's based on some multiple of that. And so that way, if you do your due diligence and you find out that, hey, this is not what you said it was. The sim said, you had EBITDA of X, and it turns out it's really Y. Then it's not really a retrade for you to go back and say, hey, this purchase price that I offered in the LOI doesn't work because I was basing it off these assumptions. And so those assumptions I think are very important to leave, to have in there so that you can make sure that you're not looking like you're retrading it later in the game if something comes up in due diligence. Leaving out deal breaker terms, that's an important one. Obviously, anything that you need in there is important to have. You got to have in there. If there's a deal breaking term on your side, you definitely want to have it in there. And then, earnest money deposits. I think this is another pitfall. We push hard to try to get these out of any LOI. It's usually never offered, obviously, by the buyers in an LOI initially, but if they push back on some sort of earnest money, that's always a potential pitfall because, who's going to hold it? When's it refundable? All those things are issues that really, I don't think should be issues in a business sale. It's more of a real estate concept, and it just adds a lot of negotiation into a deal at a stage that it's not warranted. So anyway, that's another pitfall that I try to avoid. All right. So non-negotiables. These are the big things that you got to have in there, right? Deal structure and economics, obviously, including assumptions. What is the purchase price and terms? What cash at closing? What seller notes? Any rollover equity if there's that? Working capital target methodology. All that is important to have in there. And what's assumed versus excluded liabilities is often another one to include in there if you can. And so anyway, those are the big deal structure pieces that you want to have in every LOI. Rollover equity terms, if applicable. This doesn't apply to every deal, but if you have a rollover, then those should be well defined in the LOI, I would say. Exclusivity, no shop and diligence. These are all important things. We've talked about exclusivity, which is also sometimes called a no shop provision. So if you hear that, it's really the same. And then kind of the due diligence parameters that you have. I think those are the non-negotiables, provisions you'd want to have in there. Closing conditions, those are usually pretty standard. You've completed your due diligence to your satisfaction. There's usually a financing contingency for you to get that bank loan on terms that are reasonable to you. You might have other closing conditions like you need key employee retention agreements or things like that, or there's a license or a permit that needs to be there. And so, there's going to be able to use a license, or you'll be able to obtain this license or permit prior to closing. Those are all, important closing conditions to have in an LOI if those are important to your specific deal. Reps and warranties framework. I'm getting out of turn here. Sorry. Management arrangements, non-compete. So this is obviously important. You're gonna need to have a non-compete, non-solicit expectations, transition support. All those are important things to outline in the deal, and those really depend on the seller, right? What are they willing to do? What are they anticipating? And then what do you need? That's a deal-breaking term. If you need them to stick around for a while, or you need other people to stick around for a while, you got to have that in the LOI and make sure that they're going to agree to that up front. And then lastly is that reps and warranties and identification framework. I think that is a great, I love having those in there. I think it's important. I think it's the time to negotiate it is the LOI. Because if you're negotiating it in the purchase agreement, there's a lot less leverage. And so getting it in there about what it's going to look like. What is the survivability of the reps and warranties? How does indemnification work? And, is there any caps or baskets? If you can avoid having those, that's great. But if it gets pushed back, then pushback from the seller on the LOI with caps and baskets on indemnification, then you have to really think through that and understand what are you willing to agree to there, and is it market? All right, so let's get to the prep checklist. So these are the items I think that you want to be ready. So if you're a searcher out there, we're in December 2025. Too late to get a deal closed this year, I think, unless you're already involved in it and probably way past the LOI stage and not attending this seminar. But this is the checklist that I would say you want to make sure you're working on. So one is financial capital readiness. You confirm if you're going to raise outside capital, try to get commitments on that capital. Build lender relationships. Make sure you understand what the lenders are looking for from a debt service coverage ratio, so you can put that into your model when you're reviewing financials in a company, and make sure that it lines up with that. You want to make sure that you can hit that, because if at the end of the day the deal is not financeable, then the deal doesn't close. So having those relationships, being able to talk to somebody and building those right now is important. So I'd say that get pre-approved, get a Q of E provider. If your plan or your process is to have a Q of E done, then get those people lined up right away, and make sure that you have somebody to call once an LOI is accepted, so you know that you can move forward quickly, because sometimes those can take a while to get done. Deal team readiness. This is another one. I think you want to have, it's going to sound like self-serving comment, but having your legal counsel locked in, or at least ready to go, somebody that to call, or at least a couple that you've talked to and you feel like are well positioned to help you. You might want to get those people ready to go so that you can call them quickly if an LOI is accepted, or to help work on the LOI, honestly, which is even better. And then make sure that they have the capacity to work on the deal once an LOI is signed, because things will move quickly after that. Any other diligence team that you have, right? It could be accounting, HR, tech, environmental, anything like that you might need for the industry that you're looking for. You want to have those ready to go and to move forward once an LOI is signed. So those are very important. Buyer identity package. So this is something that I think you can be working on now and be ready for in 2026. So have your buyer profile deck, strategy, your track record, what sort of your thesis is for your search, and having that set up and ready to go, so you can add that into any LOI, or to provide it to the seller or the broker to help sell you as the right buyer for any deal. Any proof of funds or financial capabilities summaries, that's also important. Putting together your personal financial statement, things like that. Those are all going to be important, not only for getting lenders on board, but getting sellers on board. So have that all prepared. Target identity prep. So this is, what targets are you looking for? If you're looking for multiple different industries, you got to set one of these up for everybody. for each one, I would say, so that it's easy for you to sell that you're the right buyer on these. It's kind of creating that. Some people often call it a buying box. What are you looking for, and what does it? What industry is it? What sort of size is it? What geography is it? All that. If you have those identified and laid out, it makes your search a lot easier. One, because it's easy to disqualify deals that aren't in your box. And then you're not wasting your time on deals that you're never going to close on anyway. So having that set up, I think, is a very important process. Internal process and timeline set. So, set some time on your calendar. Block off times for you to review deals, to review sims, to actually work on this process, especially if you're not doing it full time. Having this blocked out on your calendar to be able to do this, I think, is important. And having those timelines set for how many deals you want to look at, how many LOIs you want to submit, things like that are important. And so if you don't block it out, if you're like me, at least, if you don't block it on your calendar, there's a million other things that pop up. And so I think that's an important process here for you to set those timelines so you're ready to go in 2026 to get a deal done. So yeah, that's the process. That's the checklist. That's a whirlwind tour of letters of intent here in 31 minutes. So appreciate everybody taking the time. I don't see any questions in the chat. So I think that's going to do it. Appreciate everybody attending. Again, I know it's a busy time of year, and I think that this is a good sign that you guys are. Oh, I had somebody raise a hand. Let's see here. All right. I see a raised hand. Can you add a question in the chat? If that's a question, I just see a raised hand. I don't see any actual question. Oh, here, let me type. All right, I just sent a chat in case that pops up for you guys and you want to leave something. Okay, I may have just allowed you to talk. Looks like. Pavel, do you have a question?
Hi, hello. Can you hear me okay?
I
Hey,
hear you, yeah.
great. Sorry about that. I was typing out my question. Figured I'd just pop one in and say, hey, I got something. Um, Talk to me a little bit about, I think as a potential member of a deal team, I'm trying to assemble my deal team, my QV provider, my M&A lawyer, et cetera. Part of it is my question is that I'm not sure I have my industry narrowed down enough to really say that, hey, I want to be doing a certain type of industry. So my question to you is there, like, if sorry, this is kind of a roundabout question, but if I were to engage you personally or Doida Crow Legal today and just kind of ask about, start the process of getting you on part of my deal team, and then at some point in the future, ultimately go with another M&A advisor because maybe they have a little bit more deal experience or they're more related to my field in particular. How would you personally feel kind of offended by that? I don't want to burn any bridges by starting conversations with deal team advisors and ultimately going with another advisor down the road. But I also want to be conscientious of it. I'm not sure how prevalent kind of that dating phase in the industry is. So go ahead and
Yeah.
let me know what you
No,
think.
good question. Can you guys still hear me? I've never.
Yeah, yeah.
Okay. All right. Great. I just never done this allowed to talk thing. So no, that's a great question, and I can speak from just my personal experience on that. I'm sure you get everything in this industry, right? There's some attorneys who may get offended. For me, I want you to be with the person and the firm that in every aspect that you're most comfortable with. Obviously we hope that's us, but if it's not, we're totally fine with that. Like I don't, that has happened to us where we've worked on deals, given advice, even worked on LOIs, and then they've gone with maybe have gone with somebody else. Actually one was because we told them they should go with somebody else because there was a regulatory issue that we didn't feel like we were as competent on as we should be, and we're the first to say that. There's a lot of things to consider, right? Capacity, you got to consider their competence. Can they close this deal? Have they done a deal like this before? And
Mhm.
you got to think about, do I work well with this person? Does this person have the personality that I think because you're going to be spending a lot of time on calls and back and forth and talking about things. Do they have the personality that I want to work with, or I think it's going to lead to the deal that I want? How do they communicate? How fast do they respond? Things like that. So all those are very personal items. And, like, while I would like to believe that, I'm a great fit for almost anybody,
Yeah.
there's other people who want, different lawyers. Like, I would say we're not a scorched earth type lawyers that are trying to drag out every little issue. We're trying to get the deal done efficiently on the market terms and get a kind of a good deal for our client, obviously. But we found it's been more of a waste of time and detriment to try to have a scorched earth approach to an M&A deal. And that may not be what somebody wants. Somebody might want something different. So no, I would say for us, I would not be offended. I want everybody to be, I love this industry. I love the people, the searchers who are looking for deals. I love getting deals done. It's exciting to me. But in the end of the day, I want, more people to get deals done and to work with whoever they want. So I personally don't think that's a big issue. And I don't think that you should be worried about that, I guess. I think you should go with whoever you think is going to be the best fit at the end of the day. But leverage, along the way when you're talking to people, like we talk to a lot of buyers and we have intake calls with them and talk to them and see what they're looking for. And they may not have a deal yet, but they're looking for one. And so we just tell them, hey, this is what we think. It was great talking to you. This is how we work. And when a deal comes up and you have an LOI or you are ready to submit an LOI and you want some advice on it, give us a call and we'll see if we're the best fit. If we're not, we can recommend you to somebody else. Or if you have somebody else lined up, go ahead. That's not a big deal. That's kind of the cost of doing business. And so I just wouldn't worry about that on your side.
Super. Thank you, Trevor.
Yeah, no problem. All right. Harshdeep, I'm gonna allow you to talk now. I guess you have to unmute.
Yes. So yeah, I have a question. So as you said, and you went through all these, I guess, there is LOI, which is, separate for every business. There might be some, things that you want to customize for every deal. But so you recommend people to, have every deal customized LOI, which, you might help, or you should, person should use a template, and just modify on their own. So how do you recommend to move forward when, someone is in this process? And also, do you have a price list, for different parts of the deal where, for this much we, or so, yeah, I mean, just, if someone want to
Yeah,
work with you, how does it work?
good question. So what I would say there is it really depends on your experience and, well, whoever the buyer is and the searcher, what their experience is with preparing LOIs. I've worked with searchers who've come out of private equity and they've done, hundreds of LOIs themselves. And so they are pretty good at putting them together. And so it's not, hasn't, they're not relying on me to do that. I would say if you haven't submitted one before, what I always recommend is that you talk with an attorney, at least on the first couple, or at least the first one, to make sure that you have kind of the big terms in there. But, this goes back to having that deal box. If you have a deal box of what you're looking for, then a lot of that part, a big portion of that LOI is going to be rinse and repeat. And so,
Hmm.
we've worked with buyers where we've helped them with the first one, and then that deal died or didn't go through, or the LOI didn't get accepted, and they were able to prepare the next, few on their own because we've already gone through the process and they know what they needed in there, and they had a good template and they were ready to go. So there's a lot of great templates out there. I think those are good starting point. Having somebody take a look at it right before you submit, if it's your first time, I think is a good idea.
Mm-hmm.
And so that's kind of what I recommend to searchers. If you haven't done it before, then have somebody take a look at it before you submit it. Start with a good template. Then if you need somebody to take a look at it before you submit it on your first time, do that.
Mm-hmm.
And so that's usually the process that I recommend. And for us, we do a lot of fixed fees. So usually on an LOI stage, we bill that hourly, and it's really kind of depends on where you're at and how much help you need on it. And so we just bill that hourly. Once there's an LOI signed, then we offer a fixed fee and say, hey, we know this deal is set up right as a asset purchase agreement. There's going to be a seller note. We know there's going to be a non-compete agreement. We got some contracts to assign. We got Simon assumption, bill of sale, those type of ancillary agreements. We have some key employees we need to get into an employment agreement. Whatever it is, we can look at the LOI and know here's kind of the outline of what we need. Here's what we think it's going to cost from a price standpoint. Here's the milestones where we earn those fees, right? So it's not like the deal dies in due diligence and you get charged the whole fee. It's milestones where we've done the purchase agreement, now we've done the ancillary documents, now we've done these, and so we kind of earn fees on the way along the way. I would say, just as a general ballpark on amounts, on a typical SBA loan deal, under 5 million, 5 million and under, the fees are anywhere from 20 to 35,000 to get from beginning to end if we close the deal. Obviously, if something happens in between, then it's a lot. There's just the milestones along the way. Now, if that deal is actually a $1.5 million deal, and there's no real estate, or there's no assignment of lease, or something like that, there's reasons why it might be under that $20,000. But as a general range, I would say that's about where it's at. And where the 35 is more of, hey, we're talking a $5 million deal with some bells and whistles and things like that, that go on, like maybe there's an F reorg or something like that. So anyway, that's the general range, I would say.
Yeah, that's perfect. Yeah, that's what I was looking for. One last question: is there any resources template that you might have that people on this seminar can just have a look at it, and when they're preparing their LOI, and then they can reach out to you later?
Yeah. You know what? We don't have a ton of, we have, a decent amount of people here, but if send me an email. I'm gonna type this in the chat, and then I can send it to you. I don't know if we have one that on our website or anything like that. So I'm gonna put my
Yeah, because
email.
I already checked your website. I couldn't find it. That's why. So I should ask.
All right. Crow.com. All right. So there's my email. It's just Trevor at doidacrow.com. Send me an email if you like, and
Perfect.
I can send you something there.
I will do that. I can't see your email.
Do you see that chat at the top? Do you have access to like if you go to top of Zoom and you see something that says
Yeah,
chat?
I am seeing the webinar chat, but it said chat disabled, and I can't see anything in the chat.
All right, hold on. Let me try that again.
Or maybe I can just write it down if you can just,
Did that come up by
Yes,
chance?
now it came up. Yes.
Okay, I see my issue. I
Yeah.
had it set to just host and panelists and not everyone. So that was the
Yeah.
problem. Okay, cool. All right,
Perfect.
guys. Well, I gotta run here. I appreciate everybody joining. Hopefully you took something from this. If you have any questions, send me an email. Happy to talk about deals anytime. My email's in the chat. And if you're not in the chat, it's just Trevor at doidacrow.com, and look forward to talking to you, and look forward to hopefully you guys closing some deals in 2026. All right. Have a good one.
Thank you.